India's technology sector is currently operating in a legislative vacuum regarding artificial intelligence. Inside the Ministry of Electronics and Information Technology, the debate over how to regulate these systems is active and volatile. Technology companies, coordinating through industry bodies like NASSCOM, have heavily lobbied the government and the media to adopt light-touch, self-regulatory frameworks. In November 2025, the ministry released the Balaraman Committee report, which leaned directly toward these industry-friendly suggestions. Then, the Supreme Court of India disrupted the timeline. The court released its own comprehensive draft, Regulations for Use of AI in Courts. By establishing an internal guideline for the judiciary, the court created a rigid, mandatory due diligence standard. Any future legislation the ministry drafts must ultimately survive judicial review against these exact metrics. The Supreme Court established the baseline compliance standard for any artificial intelligence company intending to operate within the Indian institutional sector. 2 months prior to the court's draft, the Foundation of Data Protection Professionals in India published the DGPSI-AI standard. It serves as a strict compliance framework for the data fiduciary environment. On the surface, the two texts appear to conflict. DGPSI-AI operates as a voluntary industry standard, while the Supreme Court draft is a mandatory sector-specific regulation. This isometric model maps the ecosystem. The judicial building is the demand side, governed by the Supreme Court framework for procuring and deploying AI. The tech stack is the supply side, where the DGPSI-AI standard sets exact operational obligations for developers. These are not competing frameworks. They form a bifurcated ecosystem. To understand how to sell artificial intelligence to the Indian government, we have to analyze where these two frameworks intersect and where their policies clash. This matrix will map the structural frictions between the texts across 4 specific vectors. The first row charts the default risk posture. DGPSI-AI operates on a strict principle. Unknown risk is a significant risk. Consequently, deployers automatically incur the heavy legal obligations of a significant data fiduciary, unless they formally document an AI deviation justification to prove otherwise. The Supreme Court takes the opposite stance in Regulations 16 and 17 of its draft. The court mandates innovation over restraint. This establishes a legal presumption in favor of responsible AI adoption by default. Under the court's rules, any restriction placed on AI adoption must be actively reasoned and recorded in writing. The DGPSI standard prioritizes liability aversion for compliance, while the Supreme Court policy prioritizes institutional modernization. We add a second row to the matrix, human accountability. DGPSI-AI's second principle mandates that behind every AI algorithm, there must be exactly one designated human handler. This handler defaults to the organization's data protection officer or compliance officer, actively preventing diffused corporate responsibility. Regulation 8 of the Supreme Court draft mirrors this exact mechanism. The court requires a designated officer to supervise and verify outputs, taking exclusive responsibility. If an AI hallucinates, the officer is liable. The black box defense is legally invalid. The third row maps explainability and prohibited uses. DGPSI-AI explicitly ties algorithmic explainability disclosures directly to the standard privacy notice given to users. The Supreme Court enforces this through Regulation 20, which establishes a strict, non-derogable list of red lines. The court absolutely bans algorithmic-only outcomes, prohibits behavioral profiling and risk scoring for bail. Despite their differing initial risk postures, both texts dictate that autonomous algorithmic decision-making cannot supersede human legal accountability. The final vector reveals the primary structural contradiction between the two texts, the audit philosophy. DGPSI-AI requires mandatory evaluation of the AI model by an independent external data auditor. The Supreme Court's Regulation 38 explicitly rejects this, restricting all technical and ethical audits to a strictly in-house model. The court forbids source code, algorithms, and datasets from leaving court premises or being shared with any third party. If the court prohibits external audits of deployed systems, how can the public trust the proprietary models supplied by private vendors? The timeline resolves the paradox. DGPSI-AI external audits occur prior to deployment. They serve as the prerequisite trust baseline before the software ever crosses the judicial air gap. External verification establishes trust in the open marketplace, while in-house audits preserve sovereignty and security within the institution. Moving beyond legal compliance, we see a clear divergence in systemic architecture. DGPSI-AI imposes hardware-level constraints on developers. The software must feature a tamper-proof kill switch, physically isolate it from the device's main intelligence. It also mandates a fading memory protocol, which time-weights learning data to systematically force the AI to forget outdated biases. The Supreme Court draft lacks these engineering mandates. It relies entirely on Chapter 4's institutional machinery for oversight. The court requires 5 standing committees, an apex body, AI secretariats, and centralized incident databases. DGPSI-AI dictates how the machine is built. The Supreme Court draft dictates how the human bureaucracy manages it. We return to our structural model to examine where these frameworks physically intersect. The bridge connecting them represents Chapter 6, Regulation 46 of the Supreme Court draft. Regulation 46 serves as the strict contractual gateway, dictating how courts will engage private AI service providers. The vendor requirements are stringent. They include mandatory data ownership clauses, deep explainability for high-risk tools, and mandatory on-premise cloud deployment. DGPSI-AI provides the operational solution. Its 13 developer implementation specifications map almost flawlessly onto the court's technical requirements. For example, Regulation 46 and DGPSI Principle 4 both mandate strict, unconditional indemnity clauses, legally protecting the institution and the data principle from vendor-caused harm. Adherence to the DGPSI standard is the preemptive engineering of a judicial-grade AI product. This animation of interlocking gears illustrates the macro impact on India's technology sector, as these dual policies begin to actively reshape the national technology market. By setting specific procurement rules, the Supreme Court framework effectively validates the DGPSI-AI standard as the target criteria for developers. While the ministry debates national policy, the judiciary has already constructed a functional, end-to-end operational blueprint. For legal tech founders and compliance officers, the mandate is clear: align developer lifecycles with DGPSI-AI if you intend to survive the scrutiny of judicial procurement. In the Indian ecosystem, true AI governance relies on the strict contractual handshake between a compliant builder and a highly regulated buyer.